Hi, everybody. I'm Josh Goldberg, co-managing partner at Nath Goldberg and Meyer, and I'm here to talk to you about the interaction between greenwashing and intellectual property. What is greenwashing, you might ask? Well, the practice known as greenwashing is the use of false, misleading, or unsubstantiated claims about the environmental efficacy of a product or service. Basically, if you're claiming your product or your service is environmentally friendly or green, when it's not, that's considered greenwashing. How does that relate to the field of intellectual property? Well, any type of intellectual property right, whether it's patent, trademark, copyright, trade secret, can very easily be implicated in a charge or a potential greenwashing issue. On the plus side, patent rights can help you avoid a charge that you're greenwashing. If you're using an inventive technology to actually perform a new service or generate a new good in an environmentally friendly way, that's proof that you're not greenwashing and your technology really is as environmentally friendly as you say. If instead you do not have that patent, it could be the opposite. You could be susceptible or liable for such greenwashing. Trademarks, on the other hand, are very different. Everybody has seen products out there that label themselves as green, environmentally friendly, eco-friendly, anything like that. There's no requirement for a trademark that actually be true and for it to be registered. All that a registration agency like the US Patent and Trademark Office would say is that, is it similar to somebody else? Would it cause confusion in the marketplace? And is the source of goods or services well defined? And that's it. Trademarks that falsely suggest environmental friendliness can be denied registration or revoked. This is something that would normally happen by way of an opposition, revocation proceeding, district court litigation. I would say it generally involves a third party in some way, shape, or form saying that the trademark is incorrect, rather than the trademark office making that decision on their own. So what is greenwashing? How do you figure or how do you determine that something is greenwashing? Well, there are 7 common sins that would be considering greenwashing. If your advertising, if your marketing campaign makes irrelevant statements, is overly vague, uses fake labels, lies to the public, says it's the lesser of all evils, or offers no proof, these are signs that you may be greenwashing. Examples of real green trademarks are terms or slogans that include words like organic, good for the environment, energy efficient, natural, made from recycled materials, and the like. Again, the problem is whatever words you use in your trademark should be true. You should not claim that your product is made from recycled materials when it's not actually made from recycled materials. If you do, again, you're liable to either have your registration not approved in the first place, less likely, opposed, and revoked, and rendered unenforceable. And if it gets into district court litigation, if it can be proven that you knew you were lying, that could be considered as inequitable conduct, not just render your mark revoked, but also open you up and make you susceptible to fees, attorney's fees, punitive damages for unclean hands. What else is there? Well, here in the US, of course, we have consumer protection laws. There's the issue of service marks versus certification marks, both of which are relevant to green trademarks and potential greenwashing, and certification pathways. If there generally or genuinely is a certification for claiming that your product or your service is a green product, then you should follow that certification pathway. If you do, no one could make you liable or say you're susceptible to greenwashing. If not, you're probably in for trouble at some point in time. So key takeaways for trademark owners is that you have to understand greenwashing, be cautious with any greenwashing claims you might make, and understand the potential legal implications if you do something wrong. In addition to possibly having your mark revoked or not approved in the first place, there are a lot of other enforcement measures that may be available, including fines, injunctions, regulatory review, or even having a license revoked or suspended. The easiest way to not be found guilty of greenwashing is to avoid the issue. Have a factual basis for whatever green claims you're making. And again, have a patent that shows you are using new inventive technology to claim your green status. If you do that, though, you need to ensure that whatever patent claims you get and whatever claims you're making to the marketplace are material to the product you're selling. You should avoid the use of vague terms, and you should conduct green IP audits, meaning look through your patent portfolio, your trademark portfolio, and see, do you have any patents, trademarks, or the like that relate to green products or to green services? Make sure that what you're actually doing matches to what your IP portfolio is, and especially if you have green trademarks, that you're not overstating or overselling what it is you can accomplish. If you have any questions about greenwashing or any other aspect of intellectual property law, please contact us at 703-940-5620 or send us an email at ip@nathlaw.com. Thank you very much, everybody.